video is going to explain the substantially similar test as it applies to registered designs. This test is applicable to both registration of a design under Section 15 and infringement of a design under Section 71 of the Design Act. The substantially similar test can be found in Section 19 of the Act. We'll go through it in detail now. Firstly, Section 19(1) requires that the assessor give more weight to the similarities than the differences. In Keller and LED Technologies, the court held that rather than focusing on the differences between designs of two rear brake lights, if the overall visual appeal of two designs are similar, then the list of differences between them will not suffice to avoid infringement. Secondly, the standard to be applied when assessing substantial similarity is that of an informed user. This is a person who is familiar with the product to which the design relates or product similar. This can incorporate the views of consumers, experts, specialists, and skilled tradespersons. However, this person must be familiar with the nature and appearance and use of the product. And source and sell, the court held that the person does not have to be a user of the product, nor do they have to be an expert, as Section 19(4) does not impose a standard higher than familiarity. Thirdly, Section 19(2)(a) requires the person assessing the two designs to have regard to the prior art base of the design. The prior art base primarily consists of designs that are publicly used or published either within or outside of Australia. If the alleged infringing design is closer in appearance to the registered design than to the prior art base, a finding of infringement is likely. Consideration will also be given to the state of development of the art base. If the prior art base is well developed, informed users will be more aware of small differences. Alternatively, if the prior art base is underdeveloped, differences will likely need to be greater before considered distinctive. Fourthly, under Section 19(2)(b), if included, the court must have regard to the features mentioned in the statement of newness and distinctiveness. This allows the applicant to identify particular visual features of the design as new and distinct. Fifth, Section 19(2)(c) provides that if only part of the design is substantially similar to another design, regard must be had to the amount, quality, and importance of that part in context of the design as a whole. In Hunter Pacific International, the court found that although there was a number of obvious differences in shape and configuration of two ceiling fans, the differences were insufficient to displace the significant and eye-catching similarities that create an overall impression of substantial similarity. Finally, Section 19(2)(d) allows for consideration of the limitations on the freedom of the designer to innovate. For example, where there are functional limitations which relate to the common practice and efficiency of the product, features that are inherently present in order for the product to exist as that product, features required by industry standardization or law, or features dictated by fashion. In such circumstances, it is appropriate to assess newness and distinctiveness on the basis of factors which are under the designer's control. In summary, Section 19 has 6 considerations for a person assessing whether two designs are substantially similar. Firstly, more weight must be given to the similarities than the differences. Consideration of the standard of the informed user. Consideration of the prior art base of the design. The statement of newness and distinctiveness. Consideration of the amount, quality, and importance. And the freedom of the creator of the design to innovate.